do want to have chapters all over India. There's 400 cities in India with a population of over 100,000, over 1 lakh, and we want a chapter in every one of those 100 cities. We're in about 75 cities right now. We do an annual conference. The next annual conference will be in Bangalore in end of January, beginning February timeframe. And we will have about 50 speakers and at least 1,000 people in attendance, 1,000 lawyers. And it'll be an all-day long conference with keynote speakers and then parallel sessions throughout the day. So look forward to it. Please become a member of ILA in whatever city you're in. If your city does not have an ILA chapter, then go ahead and help us start one. It's everybody's organization, and so, which means it's yours. So please do with it as you please. Today, we'll talk about insolvency and bankruptcy. In India, we have a new act that happened in 2014, and a lot has happened since then, since August 22nd, 2014. And we have two wonderful panelists with us, Prachi Pandya and Bhargav Hemig. Probably pronouncing your last name incorrectly, Bhargav. You want to correct me?
It's Hemige. It's all right.
Hemig, okay. Yeah, मेरी pronunciation थोड़ी खराब हो गई है. Anyways, when you introduce yourself, the two of you, please say your name correctly, and that's good. Let's start with that. Why don't you introduce yourself and tell us a bit about your life, Prachi?
So hi, morning everybody. Hi, I'm Prachi Pandya and I'm practicing in Bombay since 2004. And initially I was part of some firms and I started on my own about like 15 years back. And since then, I've always been interested as a student in litigation. So I chose litigation as a career opportunity when I pursued law. So since then, I've been doing commercial litigation, could be in terms of securities market, capital market, the Indian capital market regulator being SEBI, so do a lot of matters relating that. NCLT, when it was formed, prior to that, matters in the company law board and commercial arbitration, etc. So yeah, I've been doing more of that as my area of practice. Personally, I trace my roots to North India, Uttarakhand, while I'm being in Bombay. So usually summer breaks of India, the court vacations are spent in Uttarakhand trekking somewhere. That's on the personal front. But yeah, happy to be here on a Sunday morning, spending time with lovely people here, exchanging thoughts on the topic.
Thank you. What's a good place to roam around in Uttarakhand?
So if you just want to explore, Rishikesh is nice if you just want to have a nice time. But if you like the mountains, Uttarkashi is very pretty. I go up north further because I do my treks. I've done a couple of them one of them is like Devariya Tal. So yeah, it's lovely there. Summers is a good time because that's bearable cold. I can't take the winter treks. So yeah, summers it is.
Till what height have you trekked?
The Devariya Tal was 14,000 feet.
All right. The oxygen gets thin over there.
So, yeah, but it was fine, wasn't that bad. Sikkim was little, that was more difficult because the air is thinner there, you're right. But Uttarakhand so far, was the levels I've done in Uttarakhand was bearable. Sikkim was tough.
Wonderful. We're jealous of you because Bhargav and I can't climb up to 14,000 feet. Can you, Bhargav?
Definitely not, sir. We are located in one of the most western parts of the nation in India, wherein cold is something or winters are something which is as equivalent to summers. So therefore, there's no winter in Gujarat or say even in Bombay for that matter.
Right.
There's rarely any winters can be found in those regions.
Absolutely.
So what city are you in now, Bhargav?
We are put up here in Ahmedabad.
Okay.
In Gujarat. So yes, we've been practicing here for the past 7-8 years. And I do a hybrid model of litigation also, corporate litigation also. We do civil litigations also. Apart from that, we are also working as non-litigating lawyers. They have a separate team for that, and we also do a lot of banking related transactions and all of that. So yes, litigation is something that I've always been interested in, because I believe that if you are graduating law, then it is must that you should at least appear before a judge. That is the least that somebody can do if you're a lawyer at the very least. So the fun in litigation is always more as compared to non-litigation. It's always more challenging. And yes, corporate litigation is one segment that has always interested me. So yes, I've taken a segue in that particular region, and we are practicing more there.
Let's put down lawyers that don't go to court as not true lawyers. That's always good.
That will be a very controversial statement for me to be making. So everybody is doing well in their own respective lives. Let's leave it to that.
So where were you born and raised?
I am essentially originally a Tamilian. So yes, I was born in Mumbai, and then long back, more of a Gujarati now than a Tamilian. So yes, that's how it is. So I've been settled in Ahmedabad for the past, say, 20, 25 years.
Okay. And your last name comes from where?
My last name comes from a village in the Tamil Nadu, which is Hemige. It's a small village.
Okay. And where do you think that name came from for the village? Who was ruling India at that time, and who was ruling that time?
Essentially, we were those Tamilians who actually fled due to invasions having happened from the Mughals, and we fled from Tamil Nadu to Karnataka. So, and we got refuge in Karnataka by Tipu Sultan at that particular point in time. So, it is then that we expanded. So, I think Hemige is one of the gods or idols there that we actually pray to and worship. So, I think it must have gotten its name from the idol.
Okay.
From the deity.
We get the message. We'll call you God Bhargav from now on. Get it. Okay, let's talk about our favorite topic, bankruptcy and insolvency. What I like about these ILA seminars and webinars we do, which is good and bad, is that we don't prepare and we don't call each other in advance and come up with a script. And we feel that the panelists we invite are smart, educated people. And we get the true answers out of them if we just ask them questions without preparation. And if you're going to be in court, you have no idea what the judge is going to ask you. So that's another good skill lawyers have, litigators have. So we'll do a fireside chat. I like thinking that we want to keep it informal, not formal. And let's say we meet at a bar and we're meeting for the first time and we're sitting next to each other and you tell me, hey, I'm a bankruptcy and insolvency lawyer, and I have no idea what that means and what kind of conversation I would have with both of you is how we want to do this webinar. And then I'll ask each one of you questions. If you feel you want to punt it and have the other person answer, then feel free to say that I'll let the other person answer. And if after one person speaks, if the other one has something more to add or something you disagree with, then please pitch in. It's lawyers and law we're talking about. There's always many sides to every story, and law has many exceptions to suit the various needs of humanity. So we want to hear different points of view. So, Prachi, let me start with you. What's the difference between insolvency and bankruptcy?
So insolvency first is the whole. Let's go a little step backward. Why this law was formulated? So there were a lot of bad debts that were surmounting in various companies, and people were defaulting on it. Now there was some the malified intents. Yes, there are always companies, but there were some genuine problems that company were facing, and the government, and they realized that they need to do something about it, as opposed to just letting them be the way they are. Hence, this law was formed. So, the ethos of this law is not to, if you're unable to pay your debt, to wind you up and just put you, in somewhere and just close doors. Is basically to see that, okay, you cannot pay your debts. It could be to your suppliers, it could be your creditors, it could be financial institutions. So, let's appoint a specialist and help you to revive your company. the ethos is to revive your company, not to kill you. So basically, if A, B, C, one, the management of the company cannot do well, fair enough. We will put you aside. We will. There'll be a person appointed, and we'll find new shareholders and management for you who can take you forward. So hence, insolvency is basically to first help you revive, and we cannot revive you, then yes, we have to go for bankruptcy, where we then dissolve you eventually if we, despite all the efforts, we could not revive you. Hence, it is insolvency and bankruptcy.
Okay. So, Bhargav, this before 2014, we had a Sikh Industry Act of 1985,
Right.
Securitization and Reconstruction Act of 2002, and Recovery of Debts to Banks Act of 1993. Are all those three acts gone or
No,
still there?
essentially the RDDB Act, which is the Recovery of Debts Due to Banking and Financial Institutions Act, is still there. The SARFAESI Act is also still there. The Sikh Industrial Companies Act is something which has completely been eliminated. So therefore, the problem was that there were huge asymmetries in the number of forums, in the number of legislations that were already prevailing in place before the advent of the IBC, the Insolvency and Bankruptcy Code. So therefore, enforcement of the orders of those respective forums, which catered to those respective legislations, also used to be very difficult and tough and cumbersome for all of those creditors and debtors and companies and so on and so forth. So therefore, because every particular legislation has its own pros and cons, it has its own procedures, has its own uh, uh, provisions. So therefore, and that resulted in huge amount of delays having happened. So therefore, one of the primary objects of actually bringing in the Insolvency and Bankruptcy Code and promulgating it is to reduce the amount of delays, right? So therefore, we are always wanting to have a statutorily defined time-bound process, which is managed by experts with an intent, as Prachi rightly mentioned, that the intent is to revive the company, find a resolution for the company rather than just knock off the company in a particular corner and dissolve it directly. So therefore, we want to save the assets of the company. We want to save the company as also not being the primary intent, but a consequent intent being that the recovery of debts also of creditors is one particular aspect that the creditors get after the company undergoes a resolution.
Okay. So, and Bhargav, the same act, IBC, applies to companies as well as individuals?
Insofar as the individual and personal insolvency is concerned, that is something, it has already been promulgated in the IBC, and there are applications being filed also under it. However, the virus of the said provisions are still challenged before the Supreme Court. So therefore, we are awaiting for a final order from the Supreme Court with respect to the constitutionality of those two provisions, which are dealing with individual insolvency, right? So
What's the issue?
the air is not yet cleared upon the virus and the constitutionality of those two provisions.
What's the issue? What is
So
what is
essentially,
it
the
the
primary
government?
fundamental issue may be that after an application has been initiated, wanting to initiate individual insolvency or personal insolvency, the insolvent individual or the person proposed to be declared as insolvent is technically not given an opportunity to be presenting why should he not be declared as insolvent. So therefore, the adversarial system is currently in question, right? Because immediately once an application is filed under either section 94 or 95 of the IBC, which deals with individual insolvency, a resolution professional is appointed to take charge of the assets of the individual, right? And so therefore, that adversarial system is something which is still missing, and whether it should be conducted in the manner which is already stated in the IBC is something which is yet to be cleared. So yes, I think the Supreme Court needs to deliberate upon it as to how do we go about it forward and clear the air on it.
Where do
Just to
you
add,
stand?
sorry.
Yeah, Prachi, go ahead.
Just to add to what Bhargav said, so and to answer your question, yes, I mean, one of the reasons that this law was formulated is to have the laws of insolvency and bankruptcy as far as corporates and individuals are concerned in one book itself, because there were other books, In fact, as far as the personal insolvency concerned is as good as an archaic act. So I think that the Act provides for resolution, insolvency of individuals, partnership firms, and corporates. As Bhargav rightly mentioned, as far as individuals are concerned, the air is not clear. So individual insolvency is not come into force. I think, to my knowledge, even partnership firms are not come into force. Yes, corporates, they are enforcing very aggressively. What one thing they're enforcing against individual under the act is if you're a personal guarantor. If I'm a personal guarantor to a company, yes, then people can come after me. So they can be insolvency against me and my assets. So that's only where the individual aspect is active as of now under the act. But per se, going after an individual and partnership firm, they have not activated the provisions under the act. It's there, but they've not activated it.
Okay. So what side of the fence are you on? And I'm hoping you and Bhargav are on opposite sides of the fence. The issue in front of the Supreme Court, what is your opinion, Prachi, that how should the court rule?
I think the court will eventually rule that upholding the provisions of the act. Because what has happened is if I'm a director or someone outside the company, at the relevant when the company was healthy and taking loans, it said it, yes, if the company defaults, I am promising you that if it defaults, I will pay you. But now, what has happened with the promulgation of this act is saying that the people are objecting to this. No, you cannot move after us. Now, I would believe that that is incorrect because at some point of time you agreed that if ABC Limited is not going to pay, you are willing to pay on their behalf in whatever capacity. You may be a friend of the director, you may be a director yourself, in whatever capacity. Now, having said that, to renege on your promise, I don't think it's fair. So I think eventually Supreme Court may uphold it at some point of time.
So are you saying there are lawyers that filed a petition that went all the way to the Supreme Court, that there's a group of lawyers who feel that even after the guarantors agreed to pay the debt, if the company files for bankruptcy, they have a way out?
They have a way out. So they think this provision, at least under the IBC, is not enforceable.
And Bhargav, let's say you're on the side of the guarantor's promise is no longer valid if the company files for bankruptcy.
Correct.
What is your argument? Why should the guarantor be off the hook?
See, as far as I believe, for the guarantors to be off the book, it may not be the right scenario because the point being is that the corporate debtor, the company which is currently undergoing insolvency or the CIRP process, has already been adjudicated before a particular forum. So, for the sake of ease and convenience, also it will be more conducive for the said guarantor of the said company to be holding or be subject to adjudication before the same forum. Otherwise, there'll be a multiplicity of forums. So, I believe if the same particular judicial forum was dealt with the insolvency and adjudicated upon the applications filed by creditors, wherein this particular guarantor or one of the guarantors is a guarantor to the loan that has been availed, it will be very easy for the said adjudicating authority to rule upon it. Otherwise, what will essentially happen is that the enforceability of the guarantee agreement will have to happen in some other court. So that enforceability will again take certain amount of time. However, this particular legislation has come with the intent of finishing up the entire proceeding and adjudicating the entire proceeding within a time-bound process. Again, there'll be delays. So we're just taking a step backwards and not forward. So that is something that I feel. So I think it may be difficult for guarantors who are already there before the Supreme Court to be. I am also waiting for the arguments that will be advanced. So it will be very interesting for all of us to be examining.
So
Do you
one
know
point.
what argument? Go ahead, Prachi.
See, one point just to answer from a guarantor's perspective, what the thought is, and there's a provision in the IPC which I feel is really not fair. So, what has happened is when a company gets into liquidation and they say, okay, we want to revive the company, and they come up with a plan. There's something called a resolution plan under the Act. So, I'm not getting to technicalities, but the principle behind it is okay. We want to revive the company. Today, there's a debt of 100 crores, but the company doesn't have the asset of 100 crores. So, a new person will come in and say, okay, I'm going to revive the company, I'm going to take over the company. So, of the 100 crores, I'm going to pay about 20, 30 crores. And at times, it is as low as that. I'm going to address claims of 30 crores. And if it is the resolution goes ahead, it is passed by the relevant bodies, it actually goes ahead. So debts of the company are closed at 30 crores as opposed to 100 crores. Then the provision of law is that, okay, the company is closing at 30 crores, but the debtors can go after the personal guarantors for the balance 70 crores. Now, if you see an individual perspective, an individual, I gave you guarantee that if he fails, I'm going to pay you, but you're letting him off the hook with just 30%, and for the 70% you're going after me. I'm an individual. So from I mean, from arguing from a guarantor's perspective, I think this could be the argument from their end.
By the end of it here, just adding to what Prachi has already said, even if we understand that out of 100 crores of debt that is currently due by the company, and the guarantor must have given a guarantee to the extent of 100 crores because the debt of the guarantor is also coexisting with that of the principal borrower. That is something which is a universal principle. However, when you seek a resolution of the corporate debtor, assuming that the assets of the corporate debtor are not worth 100 crores, as Prachi said, and it's only 30 crores, and there's a plan that is coming for 30 crores. So by for the next 70 crores, if the lenders are wanting to proceed against the guarantors, it is not so that the guarantors will also pay the entire 70 crores. They'll have their own set of assets that they might procure. Now, if the assets of the guarantor are way beyond 70 crores, then of course the debt can be repaid. If the assets of the guarantor are only 2 crores, the max that the lender can receive is 2 crores. Right. So therefore, whatever that is enhancing the value of the creditors is something which is paramount here, according to my understanding. So therefore, it is not so that a particular guarantor may hold assets to the extent of the remaining amount of the loan which is yet to be paid or not fulfilled. Right. Just like you calculate the assets of the debtor, of the principal borrower being the company, similarly, the resolution professional who's an officer of the court also calculates the assets of the individual on an individual basis. See his properties, his jewelry, so on and so forth, whatever. And there are certain exceptions also in there as to what can constitute to be a personal property of the individual and what cannot be. So by the end of it, whatever that is recoverable by the creditors has to be given back. That is a simple mechanism that is there in the IBC.
Okay, very good. You guys are very good, both of you. Let's start with some basic stuff. I run a business, let's say, I don't know, let's say a clothing company, and I come up with a new brand and it's doing really well. And then, of course, fashions change and COVID happens, or this happens, or that happens, and I can't, the business is not doing well. Along the way, I've taken 100 crores in loans from banks and other individuals and friends and family and venture capitalists. And now I can't pay the debt. And let's start with you, Prachi. I come to you and say, Prachi, I'm in trouble. I'm losing money every year. Every month I'm losing money. Every month I'm putting money in from my pocket to keep the business alive. And I've been operating like this for a year, hoping things would turn around, but they keep getting worse and worse. And I don't have any more money to put in. And what do I do with this 100 crore loan? What options do I have, Prachi?
So I want the first, obviously, on the commercial side, how you cut cost and run an organization. I'm going to delve into that. I'll come directly to IBC. So while before other people can come after you, the law also has a provision that you yourself go and declare yourself as that you raise your hands in the air, which other companies have done. Like I think Aircel did it, the telecom company of India, saying that okay, my loans and my outstanding is surmounted, I cannot pay it anymore, so I myself am making an application to court and come and help me. And hence I have an option that as a company saying that I the scenarios have changed, whatever, I cannot now run the organization, to come and help me. So you yourself can make an application and go to court before
What
anyone else.
percentage of the IBC applications are self-made, and what percentage are being driven by the people that I owe money to?
So I would say people who themselves suo moto go to court will be about 10 or 20%, not more than that. Handful of company go themselves and declare. Is ordinarily about 80% that go to court. That would be the debtors who go to court.
Do
I'm
you
sorry,
know what?
because the creditors go to court.
Right. Do you know the statistics at all of what happens in other countries? Because my knowledge is that in other countries, it's the rarely that the creditors go to court, and it's usually the owner himself herself realizes they're in trouble and they file to avoid lawsuits, to avoid the harassment. Um, and do you know why? Why? What is your gut feeling of why self-petitioning is not happening to a higher percentage?
One of the reason is that I think you maybe because you will still have some hope that the company will do well. That is one. B is that perhaps your creditors are giving you the leeway. I mean, the banks are giving the leeway. They're not immediately winding you up and putting pressure on you. So perhaps you're dragging yourself and not going to court. So there's no pressure from your other creditors, and perhaps you're pushing yourself, going to court. It's only, I think, when the water's above your nose, I think these guys then go to court. And otherwise, I think they try to push themselves because it's not a happy situation. In fact, even in terms of your reputation, it's not a happy situation to go to court and put your hands in the air that I cannot do it anymore.
Correct. And Navneet, it's a psychological thing also. Just as Prachi rightly said, if a company or an owner by himself approaches the adjudicating authority and surrenders, saying that I have nothing to pay further, and the company gets admitted, there's a public announcement that has been given. It goes on the paper. Everybody gets to know about it. So as far as possible, and these things spread like wildfire in the corporate community, in the corporate fraternity. So therefore, every person, just as Prachi said, everybody has a reputation to maintain. That so therefore, as far as possible, nobody would want to lose the management and being at the helm of affairs of a particular company. They'll try to turn the tables around. They'll try to turn it.
Right.
They'll do something.
Plus, the biggest fault most CEOs in the planet have is that they're overly optimistic.
Correct. Irrationally optimistic. Works 8 out of 10 times.
My baby, how can something go bad with my baby?
Yeah, I agree. Yeah. But I'm happy.
Okay.
I'm keen to learn the statistics that you were mentioning about.
Yeah. Sorry?
You were mentioning about some statistics which is very different outside India.
Yeah, from what I know, it's rare that the creditors force a bankruptcy in other countries. Because I think partly because if a person doesn't file a self-petition bankruptcy and they owe a lot of debt, the creditors make life miserable by filing lawsuits in court, and very quickly they can get judgments. And then the debtor then has to hire a bunch of lawyers to defend a bunch of lawsuits. And all of a sudden, you don't have money, and now all of a sudden the costs have gone through. And then maybe there's a personal guarantee, and they can get a writ of attachment against the guarantor's home and personal assets in advance of a litigation, in advance of a trial. Like within days, you can get a writ of attachment. So to protect from daily phone calls, daily letters, daily attorney letters, daily lawsuits, and threats of writ of attachment, you want to protect yourself. And one of the fastest ways to protect yourself is to just go to bankruptcy court. The minute you go, if a company has, for instance, in the United States, if the company has 50 lawsuits going on and the company files for bankruptcy, all 50 lawsuits are stayed in 1 minute. There's nothing any opposing counsel can do. Can't haul you in court. All hearings are off calendar. All court matters end. No lawyer can write to you. No lawyer can call you, harass you, bug you, show up at your office, do writ of attachments, threaten to take your house away. So it's a wonderful protection. And then you have time to work things out. So often bankruptcies are filed to force people, the creditors, to come to the table, which happens often. Sometimes we write letters to the 200 creditors saying, listen, we've appointed an advisor, a chartered accountant kind of consultant. He or she's looked at our books. We have $1 million of debt and only 100,000 of cash. And we have other assets we can sell and raise 200,000 of cash. We've been losing money. Here's our financials for the last 3 years. And at most, we can sell everything we have and give you 30 cents on the dollar. And if most of you agree, we will not file for bankruptcy and we'll write you a check of 30 cents on the dollar. And if you don't agree, we'll file for bankruptcy, and the odds are you'll see nothing, or you'll see 5 cents and it'll take 2 years. So that kind of voluntary restructuring happens a lot. And from President Trump, we know that it's a badge of honor that you filed for bankruptcies, contrary to you worrying about reputation in India. It's like a mark of honor that you filed for bankruptcy and you're smart or you survived. Anyway, so let's go back to the clothing merchant, 100 crores in debt, having trouble. Rescue me, Prachi. So what's your advice?
So I would believe yes, filing a Section 10, which is the voluntary insolvency, is a good answer in this case, because you can mitigate, because you being at the chair, you know where the company stands. So instead of waiting for the water going above your nose, you'd rather mitigate those losses at the right time, where you have some assets as opposed to no assets. So you don't want to go the Malia route, or you're really the debts are so much that you have no money to address them, or just like as you rightly mentioned, like 30 cents to a dollar. Perhaps if you take the decision at the right time, you can mitigate. Perhaps the creditors can get much more, 50 cents to a dollar, 60 cents to a dollar. So yes, I would believe that filing for insolvency at the right time is a good approach for everybody, the company and the creditors.
Okay. So Bhargav, I'm not happy with Prachi's advice. She seems to be too nice, and I want to screw my creditors and be aggressive, or I want to go seek a consultation from another lawyer. So what's your advice to me, Bhargav?
So we're defending the company here, right?
Yes.
See, we'll try to stall as much as possible. We'll try to stall as much as possible. Try to restructure that. Try to have as many correspondences with the bank, right? With the lenders, saying that you need to give us some more time. You can increase the interest rates. You can refund me. Have certain more additional debt syndications occur. I think I would want all the consortium of banks to come together and lend me again. I'll have a further proposal that I'll prepare before the bank can go, saying that the industry has certain amount of prospects. So this is purely for the company. If I want to stall it, if I have hope in the company that I can take this company forward and turn the tables around, it is only in that particular scenario. If the
What
founder,
is this process called?
there is no defined measure of actually defining this particular process. It is only that, see, this every promoter for that matter, just as you rightly said, Navneet is overly optimistic, right? So if a promoter is overly optimistic, he's optimistic about the business that he's operating, or he or she is operating, or the industry that he or she is operating in. You just need to express to the banks that the industry has certain prospects and future, and
Right.
you need to have that trust instilled by the lenders back again inside the company. We'll try that as much as possible, and the final route is yet again to go under a Section 10 application before the NCL, if the banks don't understand, if the lenders don't understand.
So let's
Or
call
wait
this
for the lenders to come forward and file an application against you. Right.
right. Okay. So let's call this a second chance process. So if somebody comes to you, if I come to you with my clothing company in trouble, your first advice to me is that, hey, Navneet, before we file Section 10, let me try to talk to the top 80% of the creditors and see if I can work something out.
Of course.
And do you actually do this in practice?
Yes, people do it. It is something which is very prevalent. Because, see, I understand that as compared to the previous recovery mechanisms, I'm sorry, I'm using the word recovery mechanisms in the wrong way, but though I understand that the object of the IBC is resolution, however, it is also aiding in recovery for lenders by the end of it, the consequent benefit of it. So, therefore, uh, the results that were actually being obtained from the previous recovery mechanism, being SICA, RDDB, SARFAESI, Companies Act, all of that, is much lesser as compared to the insolvency code. So the insolvency code is actually a better mode, or rather a better means of achieving a higher rate of recovery for lenders. Be that as it may, a restructuring is always better for a lender because they're not writing off the books, right? The client still stays in the books of the bank, but that depends purely on the intent and the knowledge that the creditors actually behold together. And for making, if there are, say, 10 different lenders in a particular company, making everybody agreeable to a restructuring mechanism is also difficult. Just as
Right.
you also rightly said, it is a mode to get all the creditors on the table. Right.
So
Insolvency code is also
in this
is only a mode to get all the creditors on the table.
right. So let's talk about the second chance process.
Correct.
Would you call up uh, just the major banks to begin with?
Yes, obviously, if somebody has more, their exposure in that particular debt is slightly or is relatively higher than the other lenders, they'll obviously have a better say. They'll have a higher say, and it's always a universal norm that people keep passing the buck, right? So therefore, if one goes ahead with it, somebody must have done the due diligence. So therefore, a minor lender might not do the due diligence. Right.
Right.
So therefore, if the major lender has done the due diligence, they can go ahead with the proposal that has come in.
And have you seen a bank agree for a second chance?
Yes, they have.
And what do they want? Do they want more security, more personal guarantee, more money, reduced compensation, sell this, sell that? Do they want to interfere in the business? Do they want to order things around?
There are various institutions in India which are also sister concern entities of banks who have special situation funds. They have certain emergency funds. So just like I think ICCI has a separate institution, Axis has a separate institution, Kotak Mahindra Bank is a separate institution, as a special situation fund or an emergency fund. All of these institutions come into play for all of these restructuring mechanisms, majority. Right. So therefore, if they see prospect in a particular company and in a promoter, and if the promoter says that I need certain additional sums of money so as to turn the tables around, and if the creditors are agreeable to it, they might actually do it for a higher rate of interest for certain additional security. And obviously, the rates of interest will be higher as compared to the previous loan that was tendered. Right. That is something which goes without saying. So if the banks see the prospect in it, I know the risks are high for the bank also, but they are eventually going to be getting paid higher as compared to what they're being paid today.
Right.
Just like you rightly said, if some resolution applicant comes inside the company and submits a plan for 30 cents on a dollar, essentially they're getting only 30%.
Right.
Right. So therefore,
Okay.
if they find the restructuring mechanism to be better, wherein they can avail at least say 60, 70, 80%, then that is much better.
So while you're talking to a major bank that owns that is owed about half of the loan of 100 crores, can the small lenders file for involuntary dismissal in bankruptcy court while you're talking to the big lender?
Yeah, of course. See, the restructuring mechanisms will have to happen with banks individually. And if it has to happen with the banks jointly, that is something which is a joint discretion of the banks. Right. So therefore, whenever a restructuring mechanism is to happen, it has to happen with individual banks. Right. Before you go into the insolvency. However, if the exposure of a particular lender to a debt is more than 1 crore, you cannot preclude that particular lender from approaching the NCLT. Right. Even if the other debts might have been restructured with some other bank.
Okay. What is the process called where the creditors are filing for insolvency? What is that called?
So it's just that you file a application under Section 7, which is by a financial creditor, right?
Okay.
And you seek admission of the company under the corporate insolvency resolution process.
Okay, so it's Section 7 instead of Section 10.
Yes, Section 7 instead of Section 10. Section 10, as Prachi rightly said, is a voluntary mechanism.
Right. So how many creditors have to join hands to file a Section 7 application?
Even a single creditor can go if their exposure is more than 1 crore.
All right. In a few countries, it has to be at least a few creditors jointly and not a single creditor is given that power.
That is actually better according to me. Right, because the debt might also already have been restructured with another creditor in the past in India, supposedly. If a debt has already been restructured in the past before one other lender has approached the NCLT for seeking admission of the corporate debtor under Section 7, and if another lender, say State Bank of India, hypothetically, has a major exposure to the entire debt that has been lent cumulatively, all put together from all lenders, then there's no point of getting SBI to the table and getting 30 cents on the dollar. Right. SBI has already restructured the debt, but they have no other alternative if this application is admitted, but to come on the table and agree to whatever is being paid by another resolution applicant. Is what my understanding is. So, Prachi,
I have so many. You asked me why we have more creditors going to court is for this reason, because the leeway that is given to them is in a single person who has 1 crore and above. Now, 1 crore is in some sense a very small amount compared with a larger company or a very medium-sized company. I can imagine a small and micro entities, but for even a medium and large entities, I can actually file a case against Larsen and Toubro as a supplier if my claim is about 1 crore, not out, which is not paid for whatever, when it's outstanding for 1 crore. So I can actually file an application for 1 crore against a company as large as Tata Steel or Larsen Toubro. So as Bhargav rightly mentioned, at times it is more like a recovery law as opposed to an insolvency and bankruptcy law, because a lot of these applications are made as a more deterrent that let's settle and clear your dues as opposed to genuinely using the law.
Right. Okay. I'm back with you, Prachi, and I like your Section 10 voluntary dismissal application. Can you tell me what does this application look like? What information do you need from me? What all do we have to put in this application? Obviously, we have to attach our financials for last how many years?
Well, I mean, I'm telling you, I did an application recently and I was representing a bank. So the company was a small company. It just had one creditor. It had taken a loan from one of the largest banks of India to the extent of 3 crores. He's saying, I just have taken one loan from this bank. My outstanding is 3 crores. It's COVID. I have not been able to pay my last 2 installments. So hence I'm filing my application. Come and help me. It was as recent as he just gave his last 2, 3 years of financials, and that's about it. It was a very simple application. It's not very complicated.
What else is required for a lawyer to collect before filing the application?
So there are prescribed forms under the law and in various regulations. You have to file that form in that format. That's about it. You give all the details, the standards, your company, your registration number, your details, your assets, liabilities, outstanding loan, financial creditors, secured creditors. You give details of that. Attach a financial for last 2, 3 years, and that's about it. If you have
And
a
do the financials have to be audited financials?
yes, they have to be audited finance.
And if your client does not have audited financials, then they need to go get audited financials?
I would believe so. Yeah, I haven't explored that part, but yeah, it has to be the provisions are audited balance sheets, accounts and
And
accounts.
where is the Section 10 application filed?
There's a tribunal formulated under the law called the National Company Law Tribunal. It has benches all over India, and you have to file in the bench where the registered office of the company is situated. So, if a company has a registered office within Mumbai or in the state of Maharashtra, it'll go to Mumbai and accordingly to various places wherever.
Okay. After you file the application, what happens?
So usually when you file the application, come up to court, and the company will have to make good its case that whatever I just mentioned, that yes, I tick all the boxes, I have been unable to pay my debts. So please pass orders. And then exactly what you mentioned happens in other countries, that there's a moratorium that other people then cannot file fresh cases against you. There cannot be attachment of your assets, etc. So all of that will happen. And if someone wants to object, they can object, but it's seldom. In my experience, I've seen people making an application. But if you make good the case that yes, I have been unable to pay my debts, this application is usually allowed, and then the system takes over. The professional, like a chartered accountant or a lawyer who is a certified resolution professional, he's appointed, and he takes over then in managing the affairs of the company.
So this act happened in 2014. Where did all these resolution professionals come from?
So at that point of time, in 2016, there was a regulation that was prepared under the Act. They said that lawyers, chartered accountant, company secretary with 15 years of experience were eligible to be resolution professionals. You had to pass certain exams and you had to, make applications to the relevant body and get yourself registered. So once you were registered, you could be appointed as a resolution professional. And then off late, what is happening last 4 5 years, I see that there are colleges who are doing certified courses for you to become a resolution professionals also. So I may not have 15 years of experience as a lawyer or any other area of practice, but if I want to be a resolution professional, I can pass those exams. There are internships happening, there are placements happening, and what I'm hearing from the younger generation, I speak with other professionals, they are taking resolution professional as a very serious career opportunity. So as opposed to me being a lawyer and having a parallel, business or a profession as a resolution profession, I know people are doing this as a full-time career option.
Wonderful. So, Bhargav, I am the CEO of the company, and Prachi's forced me to file Section 10 application. And I have 100 employees. I got customers, I got sales, I got to do production, I got to do advertising, marketing, pay these employees. And now comes this resolution professional, way younger than me, never run a business or not run a big business before. What is the resolution? Is the resolution professional going to come sit on my desk, on my chair, or what's going to happen?
Yes, that's what essentially is going to happen. So the resolution professional, once he gets appointed, he is essentially replacing the managing director of the company. everything that goes inside and outside the company with respect to any order, any employee salaries to be remitted, everything and anything in the operations of the company has to be taken care of by the resolution professional. Of course, he can retain all of the people in the company also so as to aid him in the entire process. And of course, the promoter will also be an integral part of the company. So to assist the resolution professional rather, to not perform his functions solely. So that is also one lacuna that we actually feel in the insolvency and bankruptcy code, because a resolution professional has never been a promoter. As a resolution professional, as the name suggests, is a professional. Right. He's either a CA or a lawyer or a company secretary or somebody who's always run a professional run business, or he must be a professional by the end of it. So therefore, the person, the resolution professional, RP for that matter, might not have the requisite amount of experience and the acumen to be operating a company like, say, SR Steel, right? So somebody, if I'm just with utmost respect to everybody who must have taken care of the process and all of the orders that must have come in, the RP who must have appointed might be a professional, as per the law itself. So therefore, a company which is as big as SR Steel, or for that matter, any similarly placed entities, you cannot expect a person who has just come today and sat on the desk of a company which is having, say, 2,000 employees in the company. Right? How do you manage it? You'll also be clueless, and by the time the time will already be past with respect to you have to conduct the resolution.
The fastest way to kill a company is to have a receiver or resolution professional run it.
See, of course, at times, and because there'll be a lot of problems that even the RP will be faced in terms of, because there are several responsibilities that are also foisted upon RPs to be performing in addition to operating the business during the course of insolvency, during the course of the CIRP process. So he has to collect.
Isn't there a provision in the code that the debtor can stay in possession and be the resolution professional and no outsider comes in, that I'm allowed to run my business? I'll give a monthly report to the court, but let me run my business, because if there's anybody who can juice as much money as there is that I can get so I can pay the creditors, it's me, because I've been running this business for 20 years. The largest three accounts are going to vanish if they find out I'm not at the office.
That is true. However, the point here is that there's also a concept of, I don't know whether that is actually relevant right now or not, but there's a concept of avoidance transactions and preferential transactions having happening in the insolvency and bankruptcy code. So therefore, essentially the intent being is that we do not want the promoter to be inside the company, because he would, since, as you rightly mentioned, he would know the company better than anybody else. He would know where to find the money first and where to put it in his or her own account. That is also one thing that is a loophole. So therefore, we wouldn't want the promoter to be involved in certain, how do I put it, unscrupulous methods inside the company while staying in the company. So therefore, there's a neutral person who has come on paper. There's a neutral person who has entered the company and wants to run the company, because, see, it is something which is already known to the public. There's a public announcement already being made. Everybody aware about that particular entity knows for a fact that, yes, this particular company has been admitted into the CIRP process.
So there is no provision for the debtor to stay in possession of the business?
There is none. However, the debtor can suo moto voluntarily stay in the business and assist the resolution professional on a neutral basis. However, the management of the company rests fully with the resolution professional and his team.
Right.
Till the moratorium is in place.
So I'm sure you know this, that in a majority of the developed world countries, majority of the time, the person filing the bankruptcy, the debtor, stays in possession of the company. And it's only rare circumstances where the debtor is caught cheating or lying or committing fraud, then one of the creditors moves the court to have the court appoint a receiver. And it's generally, the judges would also say that the fastest way to kill a company is to appoint a receiver, because the receiver doesn't know the business, and the business is a very competitive world. And then the competitors find out that this receiver is now in charge and he or she doesn't know how to run the business. So they'll come in and try to sue the clients and the employees. Plus, the receiver, the resolution professional, charges so much money that becomes a hindrance. So it's kind of sad that our IBC doesn't have a provision for the person filing for bankruptcy staying in possession or running it. Okay.
In addition to what actually Prachi had rightly said and the question that we posed some time back,
Yeah.
I'm sorry I'm taking a segue here in terms
Yeah.
of whatever documents that are required to be submitted for an admission of an application either under 7, 9 or 10. There's another very crucial pillar of the IBC, which is an information utility, right? So NECL is the only information utility in today as of today, which is National E-Governance Services Limited. So an information utility by the end of it is a body which is acting as a repository of information, which is essentially collecting information, authenticizing it, adding credibility to it, disseminating it, and it is any information that is confirmed by the NESL, which is the information utility, is deemed to be authenticated. So therefore, now there was an amendment that was made in the previous year in 2022, wherein they said that any creditor who wishes to file an application under either 7 or 9 will have to first file its claim on the information utility website, which is a very seamless process. I've actually assisted a lot number of lenders in it, and it's a very nominal fee that is required to be paid. I think not more than say 250 or 300 rupees for a financial creditor, no matter what the loan amount is. Right. So you just feed that particular information. The information utility, say NESL for that matter, will pass on certain reminders to the debtor on a routine basis on the email IDs and on the addresses that are mentioned on the MCA portal, on the Ministry of Corporate Affairs portal. And if they also, the corporate debtor also has a right to dispute that particular information or claim that has been filed by the creditor within a particular period of time. If that is not done, and there are 3 consecutive opportunities that are granted to the debtor to be disputing that particular claim or raising any objection to it. If there's no objection raised, then that information or that claim is deemed to have been authenticated. So therefore, that particular person will have a very bleak chance to raise a particular dispute with respect to the claim that has already been authenticated by the information utility before the court. Finally,
How much does the RP get paid to run the company?
that differs. So it's something which is decided by the committee of creditors solely, and that is there's also a mechanism now with respect to the fact I may not be that aware with respect to the amount or the caps on the fee. However, there is a fee structure that has actually come in place as per the resolution information professional regulations. There is a fee structure that has actually come in place as to how do you charge it, and there's a certain amount of assignments only that the RP can take at a given point in time, so that an RP or an IP for that matter should not be overburdened, that he or she is not able to handle either of the companies. At any
What's
given
an
point
IP?
in time, sorry,
What's an IP?
IP is an insolvency professional, one and the same thing. So,
Okay. Uh, so what happens after the Section 10 application is filed? How soon after the application is filed is a RP appointed?
immediately on the date of the pronouncement of the order, there'll be an RP that will be appointed.
So you have a first court hearing within 30 days after filing?
Yes. More or less, you'll have a first court hearing within the next 30 days from filing of the application. More or less.
And the first day the court is going to appoint a RP?
No. Now, the point here is that whether it be a Section 7, 9, or 10 application by an OC, by an operational creditor, by a financial creditor, or by the debtor himself, by the corporate debtor himself, it all takes a certain amount of time because we're always in an adversarial system. We believe in an adversarial system of law. So, therefore, even after a notice is issued, on the first hearing, a notice is generally issued to the other side, which is the creditor or the debtor or whoever it is. And then on the next date of the hearing, there'll be a lawyer appearing for the other side also. There'll be hearing conducted over the period of time as and when the matter progresses. Ideally, there is 14 days that is prescribed as per law in the insolvency code, that within 14 days there has to be an admission or rejection of an application. However, unfortunately, considering the amount of burden that is currently vested with the courts and with the NCLTs, it is becoming extremely difficult for the NCLTs to be deciding an application in 14 days. Right. It takes at least, I think, on a usual basis, takes at least 3 months, is what I can think of, 2 to 3 months.
Okay.
If not more.
In the meanwhile, the person that owns the company is running it.
Yeah, he's running it.
Right. Okay. Prachi, you can hear us?
Yes, I can hear you. I don't know, for some reason my video is paused, but yes, I can hear you here.
Okay. So what happens next? RP is appointed in 2-3 months, and then I've given my financials. They have a good history of what has been going on. And the RP comes in, and I'm a nice person, so I say to the RP that, hey, I'll help you run the company fine, we'll pay you what the court ordered, but let me help you. And what is your experience? Are RPs happy to take the founders' help, or they're like, no, you get lost?
So more or less, I think my practical experiences get lost because I think the whole thing is like perhaps you could not run the company well enough, and hence we are appointed, so they take over the company. That's been my practical experience in the matters that I've done. But having said that, yes, once the application of voluntary insolvency is allowed and the resolution professional is appointed, he will then invite claims from the public at large, saying that whoever owes the company any money, please come forward and make your claims. He'll
How is
take
that done?
help is because then he knows whether what the company has disclosed, and he wants to know if other than what company has disclosed, is there anything more, because then
Is
he
there
has.
an advertisement in a newspaper?
Yes, it's a public announcement in a newspaper, in two leading, so widely circulated newspapers, and that whoever has claim could be financial banks, it could be individuals also who come forward and make their claims in the prescribed form and within a prescribed time. And then he takes a clear picture that these are the assets of the company, these are liabilities. And then he makes a document which is called the information memorandum, which is nothing but the entire the details of the company. So once that is prepared, then someone else who wants to come forward and take over the company, on that basis, he will make a proposal that on what basis and what are his terms to take over the company.
This memorandum is done. By this time, 9 months have gone by, or 1 year from the date of filing?
It would be, yeah, within a no, it will be lesser than that because the entire sorry,
Okay,
pardon.
so 6 months.
Yes, yes.
Well, you have to put an ad, you have to look at everything, you have to review. And the RP is not necessarily a financial wizard, so he's also hiring outside CAs to help him understand
Absolutely.
what is going on.
Absolutely. Like in the case of ILA and FS, which was one of a big fall down as far as the corporate insolvency is concerned, they appointed professionals as big as Grant Thornton to help them because it was practically impossible for an individual or any RP to do that by himself. So they were professional agencies appointed to help him to filter the claims.
Okay, so 9 months have gone by, let's say. Then what
Yes.
happens?
Then once the application, the memorandum is ready, the claims are crystallized, are allowed, disallowed, the entire table is ready. The applicant who wants to take over the company will make his application, put down the terms, whether he's giving 50 cents to a dollar, 60 cents to a dollar, whether there will be an amalgamation, there will be a merger, anything, So it's like a scheme. He'll prepare a scheme that how he wants to address the claims of the company, how he wants to run the company going forward, who will be the promoters, etc. He will give a
So we
proposal.
so we so we missed one step, that somewhere in this 9 month process, the RP has let out the word that, hey, if you want to take over this company and you want to run this company, then make me a proposal.
Correct.
Yes,
Okay.
yes.
And how is that done?
So
How
again,
do you find people?
notice, public notice.
Okay. And by that time, RP has come to know the other vice presidents in the company and maybe is smelling that somebody else is interested in buying. So through the grapevine, maybe?
So,
Yes, so see, obviously there will be people who will be approaching him, and because the word would go out, so people in the
Okay.
similar business would like to come forward and take over, assets of the company. A government company, perhaps a larger government company, wouldn't mind taking over this company because it has the infrastructure, the assets, the intellectual property, and the employees know the business. So perhaps in the similar people in the similar business would approach the RP and formally make an application. And then once the application is made, it goes to this committee of creditors who are nothing but a body of creditors, financial creditors. They will
Okay.
approve it. And if they approve it, then it's a mere formality for the court to approve it because the court would
Okay.
rely
We'll come back. We'll come back to this fork in the road. In the meanwhile, I want to ask Bhargav. So Bhargav, parallelly, you first of all, you mentioned Section 9 a few times. What is Section 9?
Section 9 is essentially an application to be initiating corporate insolvency resolution process by an operational creditor, say a vendor or a supplier, so on and so forth. Right.
Okay.
So
And section 7 is financial
section 7
creditor.
is a financial creditor.
Okay. So everything you heard Prachi say after the petition is filed and within 2 months an RP is appointed, and then we were all the way to advertising for does anybody else owed money by this company, and then finding somebody to buy this
Correct.
company and auctioning, and I stopped her, and we'll go back to it. But I want to ask you on section 9 and 7,
Yes.
is the process exactly the same?
No, it is slightly different. So there's a very interesting topic that I actually wanted to raise out here, and I wanted Prachi's suggestions and I want everybody to interact here if anybody is interested. So there's a very interesting thing in section 7. If we read the definition of what is a financial debt, it essentially states that it is a debt that is disbursed against interest, if any, against the consideration for time value of money, and includes certain subclauses, that is A to I. Right. So I feel that the major component of a financial debt is the consideration against time value of money. Right. And that is a very crucial aspect of the parental clause itself. However, there is one judgment that I wanted to point out, which is very interesting, by the Supreme Court recently in, say, 2022, I suppose, by the name Orator Marketing versus Samtex Designs, which essentially said that even an interest-free loan that is disbursed by a creditor to a debtor can be falling under the definition of a financial debt. Right. Now, the NCLAT, the National Company Law Appellate Tribunal, had ruled that since the loan or since the debt did not comprise of any interest component, so therefore it cannot be said that the debt was disbursed against the consideration for time value of money, and therefore it cannot be regarded as a financial debt. However, the Supreme Court reversed that particular decision and said that no, even an interest-free loan can be regarded as a financial debt. In my understanding, with utmost respect to the observations of the Supreme Court, is that I believe, how can my understanding, very laymanistic understanding of it is, 1,000 rupees today may not be worth 1,000 rupees after 5 years. Obviously, the value of 1,000 rupees after 5 years will be, say, 900 rupees, whatever, XYZ. If there's an interest-free loan, then what is the benefit that the creditor is getting? So therefore, the element of time value of money is not adhered to. That's a parental clause. Right. So how can an interest-free loan be categorized as a financial debt is something which I am not able to understand. As per the judgment, the judgment has not dealt with it. It is completely silent on this particular aspect.
Maybe the owner wants to give an interest-free loan.
I thought so. So I thought whether a sister concern company might have remitted money to another sister concern company of its, or a promoter might have remitted money to a company, to another company of his. If that is the case, I understand that interest-free loan is given. Otherwise, what is the point of there being an interest-free loan in the very first case? It was not so. It is a different entity. This is a different entity. They are not even related parties. So that is one interesting question that I feel.
Sure. Okay. So otherwise the process is the same, right?
Otherwise, the process is that under the Section 9 application, which is filed by an OC, you essentially have to submit all of the documents which are proving the fact that, yes, you had supplied certain amount of materials to the other person, to the debtor. That you have to give them a receipt, you have to give them a proof of delivery, say either it may be a lorry receipt or either it may be an e-way bill or all of that. You have to give them signed invoices, you have to give them a copy of the agreement that you must have entered into, and all of those email trail that you must have exchanged with respect to you demanding certain amount of money. Now, even WhatsApp conversations are considered to be legitimate. So therefore, you can even annex WhatsApp conversations to the application that you're filing, just to showcase that, yes, I've demanded this amount of money that is due and payable multiple amount of times, and there is no response from the other side, and they are not paying money deliberately. So that is one thing. And a very important thing which is preceding the filing of the application, which is a demand notice. Right. A demand notice will have to be filed. That is the first step. That is the prequel to filing of an application under Section 7 or 9, for that matter. Right. So a demand notice in a Section 9 application, before filing a Section 9 application, will have to have all of these documents. And there is a limit of, say, 10 days that has been given to the debtor to be raising a dispute with respect to whatever amount that has been sought for by the creditor. Right. That dispute may be in the sense that if I have supplied certain amount of materials to, say, XYZ, then the materials that were supplied were bad in quality. There were certain things that are not right. The desired quantity that was asked for is not supplied. The desired quality that was asked for was not supplied. If I had asked for a certain
What if the
section,
debtor objects? What if the debtor objects for the heck of it because they know if they don't object, this person's going
they
to
should
file a
have
section?
objected it. They should have objected it prior to in time when the goods were delivered. So a demand notice is issued later. So you just give those evidences that I had objected to prior in time, and I put all of those evidences on record by a reply to a demand notice. So if
Sure.
you're not able to raise demand notice, if you're not able to raise disputes within the 10-day period after issuing a demand notice, it becomes very difficult for convincing or persuading the NCLT to consider my disputes that I raised before the court later. That will look like
Right.
an afterthought.
So Prachi, there's 500 creditors. Who gets on this committee of creditors?
Only financial creditors. So financial creditors are nothing but financial institutions. So there is a differentiation under the law amongst operational creditors and financial creditors. Someone like a supplier is an operational creditor. He won't have a seat in the committee of creditors. Only
He will
banks,
not. He will
no,
not have a seat. Okay.
not. Only banks and financial institutions would have,
Okay.
yeah, a seat on the table.
That doesn't seem fair. If the OC is 10 crores and the bank is 1 crore, the OC doesn't get a seat.
You're absolutely correct. So this issue went right up to the Supreme Court, where people challenged that this is violation of Article 14. This is not equal. Why they should be treated differently. However, that's a topic of a separate topic by itself. But the bottom line was Supreme Court held no. There is a reason that we have this in the law, and there is a distinguishable factor why operational creditors are different than financial creditors, and hence it should be only financial creditors who should be a part of the committee of creditors.
In one country, I'm familiar with the top 20 creditors are asked, do you want to be on the committee? And whoever says yes is on the committee.
Interesting.
Most people say no. I already lost money. I don't want to waste more time. I'll depend on the other wonderful creditors, and hopefully they'll do a good job. But they'll attend the meeting and see who's getting on the creditors committee. If good people are getting on, they'll say, okay, fine, I don't want to be on it. It's more work, right? You already lost money. Okay, so how many people are in this committee?
It can be even one or two people also, because ultimately is only financial creditors. So if you have basically one financial creditor, it'll be just one person. If you have more than one, it'll be two or three. And because ultimately, see, committee of creditors is like a shareholder of the company. So
Right.
going forward, they're going to vote for all the decisions. So depending on, suppose A, B, and C are three financial creditors, depending on the outstanding loan, they will have a percentage of voting in the same.
So wouldn't it be fair to say that in half of the cases, then it's just one bank?
Yes, and yes, it's unfair. I believe it's unfair.
So there's the creditors committee. So basically, we've handed over the company to the banker, and that's it. Okay, see what you can do to see if you can save your money on your own. And if you can't, then sorry. But here, all the power's with you now. Okay, that's one solution. Okay, so Bhargav, what happens after the committee of creditors is appointed? What's next step?
So after the committee of creditors is appointed, there is an expression of interest that is given by the resolution professional, which essentially puts an advertisement to the world saying that whoever wants to submit a plan for this particular company can submit their expression of interest on the basis of the eligibility that we have decided. Say any resolution applicant or the person who wants to purchase or acquire the company on the basis of the subsisting assets will have to have a minimum net worth of so and so or a turnover of so and so XYZ that is decided by the committee of creditors internally. And if anybody who's meeting that particular threshold, they have to provide the evidence of meeting that particular threshold and submit an EOI, right, within certain amount of days. So essentially, what as in pragmatic scenarios, what essentially happens is that if there are 10 EOIs that have actually been received for a particular company, finally by the end of it, whenever the plan has to be submitted for acquiring the company, there'll not even be a single person. So essentially, that is actually good that every person in the market or in the industry is aware of a particular company being run or being declared as admitted under the insolvency process, right? So a lot of people are submitting EOIs because that's just an empty formality. It is only after that that a plan is invited that you have to submit a detailed resolution plan in the mode and manner that is prescribed under law. And
So
you
in
have to,
majority of the times, the competitors are submitting bids.
yes,
because they see
whenever a resolution plan is also submitted, you'll have to give a background of the resolution applicant or the person wanting to provide for the plan. You'll have to give a background of it. You'll have to give a background of the promoters, background of the directors, the KMPs, and you'll have to tell us what the previous businesses that you guys were doing. Right. On the basis of all of that, if this particular person is worthy enough to be taking off this particular company on the basis of the commercial plan that he's wanting to submit, because many a times the one thing that is a bare minimum is that every plan value should be higher than the liquidation value of the company. That is a bare minimum. However, there will be different changes between several submission. There were several resolution applicants who are wanting to submit a plan. A person may want his plan to be structured in a payment mechanism that is deferred over a period of 5 years, right? Wherein he'll be offering a higher amount. Otherwise, they'll be on the same side of the spectrum. There'll be a different resolution applicant who's saying that I don't want to have my payment mechanism over 5 years. I'll give it in the 2 years, but I'm giving a lower amount. There'll be a third person who will be giving even a lower amount, but at the same very first instance. If today I'm giving you the entire amount, take it, leave it, give the company to me, no 5-year business. Right. So therefore, there are at times I've seen instances practically wherein the committee of creators have approved the plan of the third person because they're getting the money today.
Can the resolution professional put in a bid for himself and herself to buy the company?
No.
No,
He's
that's
merely
not
an officer of the court.
Okay. All right. So there's 5 wonderful plans, Prachi. What is the judge supposed to do?
The best bid gets it.
Okay.
Basic judge cannot do anything here, So as the law is basically the entire power to uh, approve or disapprove an application is only on the committee of creditors.
Okay.
So
All
the
right.
proposal of law is that they rely on the wisdom of the committee of creditors and they believe that they would be the right person to agree or disagree or approve or disapprove. And as I mentioned, making an application to court after COC agrees it is mere formality.
Okay. So the judge basically approves whatever the committee of creditors
Yes, there are
decide.
few criteria that it should be the best interest of the company. It should be not a violation of any provision of law. So, except for these basic criteria, otherwise it relies on the wisdom of the committee of creditors.
Okay. And by the time these plans are submitted and committee of creditors looks at the plans and approves one, and the application is in front of the judge, how much time has passed by?
Not more than a year and a half. So, or the law provides it should close within a year and a half. You can seek certain extensions, but it is not indefinitely that goes on for years, unlike other civil proceedings in the Indian courts.
So while this company is running for a year and a half and the company runs out of money and the RP needs 1 crore to run the company, where does that money come from?
There's a provision for interim financing also there.
Yes.
So therefore, in the course of a RP wanting to run a company, there are certain financial institutions who actually want to lend. Just like I mentioned previously, there are special situation funds, right? Or the lenders themselves can lend more money. But however, their debts will always be in priority to any other, whatever amount that is currently proposed by a resolution applicant. The first thing that goes, apart from after CIRP cost, which is the cost that have been incurred, say, so as to run the entire business, say, by the salaries and all of those things, certain CIRP costs, the first in priority is the interim financing method. Because they'll get their interest, which is slightly higher as compared to the market rate of interest, and they're lending money at a time of stress and risk. So therefore, their risks have to be adequately compensated.
Right.
So, Navneet, just to appreciate, just taking the philosophy of this act, the whole purpose is that the company, even though you're agreeing that this should be restructured and there's a problem with the company, the philosophy is to take it forward as a going concern. So, liquidation is a last resort. So, even though a resolution professional is appointed to take over charge as opposed to the board of directors, the concept is should continue as a going concern. So, in terms of the basic infrastructure, in terms of the electricity, water, employees, they all continue running. You can, the RP and the COC have the powers to raise money, appoint professionals if required, lawyers, chartered accountant, other professionals, to ensure the company continues as a going concern before someone else takes over. So yes, raising of finance is an integral part of during the process of the insolvency.
Right. So Bhargav, let's talk about the poor founder who's sitting by the sidelines watching all this, I would imagine that in majority of the cases, the founder owner is also going to submit a plan.
No. So essentially, there are certain people who cannot submit a plan. There are certain restrictions upon people who cannot submit a plan. So unless and until the entity is declared or is an MSME, is registered as a micro, small, and medium enterprise as per law, right, under the MSME Act, and is registered as one, which is based upon certain eligibility criteria that your turnover has to be less than so and so. You have to be a company incorporated within in the past 3 years or 4 years. I'm not very well aware in respect to the specifics. But if a company has been declared as an MSME, it is only in that particular scenario that the founder or the promoter of the company can submit a plan for its own company. Otherwise, if the company has not been declared as a micro, small, or a medium enterprise as per the MSME Act and the relevant provisions, then a plan cannot be submitted by the founder or the promoter.
Is
At
that
times,
fair?
there have been scenarios which is incorrect, which there are certain loopholes which have actually been avoided and certain stringent measures have been taken by the courts to that effect. That founders tend to submit plans through another entity which is not connected, and the money is infused by the founders.
Right. But let's first talk about the law. Is that fair that in this free world that the founder cannot submit a plan?
Uh, essentially, it should not have been so. In an ideal world, the founder should be allowed to submit a plan.
Because
However,
the judge is approving, right? The committee accreditors is approving. Nobody knows this business better than the founder. Yes, XYZ happened and they lost a lot of money and he or she had to seek bankruptcy protection. But so here's a reason why I feel that it's not fair. One, it's legally in a good capitalistic system, there should be complete freedom. But the other big reason is the minute you tell a founder you can't do it, then the founder will find an aunt or an uncle or a dead person and whatever, and they'll try to put in an application in that person's name. They're not going to sit quietly at home. This was their baby for maybe 45 years.
correct. So it's essentially, look, sir, it's a deterrent provision that we have brought into effect. Right. So essentially, we do not want if there's a scenario wherein the promoter himself or herself takes over the company, that will essentially result in a mockery of the system. That'll create a mockery of the system. Is something that the psychology is behind it. That if an operational creditor whose debt is say 1 crore uh, is pending for the past say 2-3 years, and this particular person has again taken back the company, given zero to the OCs, right? That will be something which cannot be acceptable to the OCs, right? They'll have to take it with a pinch of salt, but it'll be taken very seriously by them, right? It'll be a mockery. So if some other person comes in and says that I'm only giving you 100 rupees against 1 crore, that is something that might still be acceptable to the OC. Ki boss, chalo, theek hai, there's a different person who's coming in inside the company and giving me. But the same person not giving me anything and paying 30 cents on a dollar to a creditor will be taken in a negative manner. And the system may not work in the manner that is ought to work in.
Right.
So the
So
other
Prachi,
reason also,
yes.
sorry.
Yeah, so I wanted to ask you a question. We've got a few minutes left. Wanted to ask you a question. In some other countries, a number of the developed world countries where bankruptcy has been prevalent for over 100 years, they have two sets of bankruptcies. One where the debtor has nothing and the creditors are not going to get much, and it's a complete insolvency and complete bankruptcy that the company is going to be dead. And the other bankruptcy provision that exists in these countries is more like a reorg, where the founder is told that we're giving you 4 years to pay off all the debt every month. So you owe the banks and everybody else 100 crores, and we're giving you 4 years or 5 years or 6 years. Run the company to the best you can. Give us your monthly financial statement, and the net profit, please surrender it to the court for the next 50 months. And we will take that net profit and distribute it to everyone pro rata over the next 50 months. At the end of 50 months, whatever anybody got, they got, but the story ends. After that, you're free to run the company on your own. Is there any such provision in the IBC?
Not exactly what you mentioned, but to some extent, because as I mentioned, that first is an opportunity to revive the company. So here, the promoter is not getting the opportunity because there is an embargo for him to because once he says that yes, I cannot run the company, someone else is put into the seat, and he doesn't have the option to come back to the seat at all, as Bhargav elaborated on that. But yes, you are given an opportunity, someone else will come into the seat and try and run the company. And if there's no one who's willing to run the company, or there are no assets in the company, no one can be paid, then finally you get into liquidation. So if the resolution plan provides for 4 5 years and it's approved by the committee of creditors, then yes, you can run the company in the manner agreed in the resolution plan, that over a period of 4 5 years we will address all the liabilities, and then the new promoter takes it ahead. If that fails, there are no takers or no liabilities that can be addressed, and then the company is finally killed by way of liquidation.
Your thoughts, Bhargav?
So, insofar as even if there's a deferred payment method that is already prescribed in a resolution plan by a resolution applicant, that is also further added more veracity and credibility because there's a monitoring committee that is appointed, right, after the approval of the plan, which is also headed by the resolution professional, in some cases by some other member also, wherein the monitoring committee makes sure that whatever that is stipulated in the plan, that say XYZ have to be completed in set number of timelines, say T plus 30 days, T plus 120 days, T plus 360 days. Accordingly, all of those timelines will have to be adhered to. So essentially, the monitoring committee, which also includes the creditors who have approved the plan in the very first place, will have an opportunity to be expressing their opinion even during the implementation of the plan. Right. So that power has also been given as per the IBC. So that is an additional power. I consider that to be very relevant here because, and even if there's some non-implementation that occurs in the course of implementation of the plan, the creditors can again track the company to the NCLT and the resolution applicant to the NCLT rather, I'm sorry, wherein that you had promised these many things to happen, but it has not happened. Why has it not happened? So those questions can be raised before a judicial forum for further adjudication also. So that is an additional power that is given. However, drawing certain a net profit and all of those, whatever you mentioned, which is very relevant, can I think be done on an informal basis in the garb of a restructuring mechanism rather than in the form of the IBC, because the IBC unfortunately does not provide for it.
And the 4 years deferred payment plan, if
Yes.
that the creditors committee approves, who's running the company? RP, or can we ask the founder to come back?
No, we cannot ask the founder to come back. It is the person who has submitted a plan for taking over the company. So the acquirer of the company, the resolution applicant of the company, essentially will be running the company on a clean slate basis. That is, I think, one of the most major principles that we should discuss, which is that after the plan is submitted and the company has been taken over, from that day, the company can be run by the applicant, by the resolution applicant, the person acquiring the company, on a clean slate basis, on a fresh slate basis. So therefore, all proceedings, all suits, everything that's pending against the corporate debtor, the company, prior in time, before the approval of the plan, stand discharged. Right. So that is something which is sought for in the plan by a lot number of applicants. And generally, as a practice and as a norm, the adjudicating authorities accept it subject to orders from the relevant court wherever such proceedings are pending.
So section 7 or 9 or 10, this pretty much explains why self-petitions is such a low number. 7, 9, or 10, the founder's baby is gone from the founder's hands.
Yes.
Correct.
Yes.
Okay. Which is contrary to what happens in bankruptcy procedures of a majority of the other countries where the bankruptcy has been going on for 100 years. In all of those systems, the law provides as much as possible for the owner of the company be given an opportunity to fix the debt and get a fresh start. And they believe that the amount of money RP charges, the inexperience RPs have, and the motivation RPs have, like the saying in these countries is the fastest way to kill a company is to appoint a receiver. And that's a huge threat. Let's talk about the most important thing, and then it's going to be lunchtime. in India in 3 minutes. So let's talk about the most important part. How are we going to get paid, us lawyers? Is our fee a preferential item?
Yes, it's a preferential item. So therefore, as I had mentioned some time back, it's a part of CIRP costs. So therefore, if any lawyer has been engaged by a resolution professional to be appearing, to be representing the resolution professional before a particular forum, be it may be the NCLT, it may be some other high court, because the proceedings that are already pending against the corporate debtor have to be attended to now by the resolution professional, because he's at the helm of affairs of the company.
Before the RP comes in, what about the lawyers that are filing the 7, 9, 10 applications? Is that fee preferential?
No.
So that we have to get from our client.
Correct. So
either the bank or the owner.
correct.
Okay. And that is whatever the parties negotiate.
Correct.
Okay. And I know us lawyers hate talking about fees, but to the 1,000 people that will see this on Facebook for the next 5 years or whatever, can we give some rough ideas? I'm not asking you what do you charge, Prachi, and what you charge, Bhargav, but what have you heard other lawyers charge? What is the going rate in big cities, small cities for a 3 crore, 5 crore, 7 crore bankruptcy?
See, it also depends upon, Navneet, on what stage you're actually being inducted for conducting or appearing in a particular proceeding.
Day
So
one,
if
as
you're
I
on,
walked into
sorry?
your office. Day one, as I walked into your and Prachi's office with my clothing company, uh, let's say 7 crores in debt, 6, 7 banks, 50 operational creditors, and I have no money and I'm willing to surrender my company. What are you going to charge me? Or what do other lawyers charge me?
It'll always be higher. It should rather ideally always be higher for lawyers to be charging a higher sum of money from financial creditors and other creditors who are owed a huge sum of money. Because by the end of it on paper, you can also see that this person had so much amount of money in the past that he paid to this person in the very first place. He lent it to this person in the very first place. However, charging it from a debtor will be subjective, something which cannot be defined because every
5
debtor.
lakhs is 5 lakhs too much for a 7 crore debt?
So Navneet,
Nothing
what
too much.
I've seen
Nothing.
is
Go ahead, Prachi.
so what I have seen in my experience is assuming a client comes day one to the lawyer saying either it could be for any application, 7, 9, or 10. Depending on the claim, the amount, depending on how big the firm is or how big the claims are, it can vary from 30,000 rupees to file an application to 3 lakh also. I have seen that. It could be much more also depending on the larger the organization and larger the law firm also. But I have seen that's the disparity or the bandwidth from 35,000, 30,000 to running into lakhs.
Right. And if the biggest bank of the country comes to you, then the fee could be more than 3 lakh.
In fact, the largest banks don't pay that
Don't pay
much.
that much.
All right. So that's how life is, right? The medium level people end up paying the most amount of
Yeah,
money
that's
for
true.
everything in life. Right. Get it. So just like all of our other cases. Wonderful. Hey, Prachi and Bhargav, this was just wonderful. I learned so much, and I hope all of our listeners learned a lot. Um, and let's do it again. We'll do some advanced topics next time. I think I made a list of about 15 items. We covered 4 or 5. But I think it's important that when we do this part 2 of this, we will tell our audience that you need to first watch the first part we did. So then we can start with the advanced part, and we'll start with waterfall mechanism next time.
Right.
But you guys are just absolutely wonderful. God bless you. Thank you so much.
Thank you
Thank you.
so much.
Thank
It
you
was a
so much.
pleasure.
All right. Keep up the good work. Thank you. Thank you.
Thank you so much.
Bye.